Dear students, good morning. Well, this is a new lecture in the field of private international law. Well, in the previous lecture, we were talking about the other sources of private international law, rather the first source, which is the international treaties. So we discussed the custom as one of the sources of private international law, the international judiciary as a source of private international law, despite the fact that the international judiciary decisions of the ICJ, especially, are so rare, simply because the conflict which is brought before the case must be between states. So the parties of this conflict and the parties to the proceedings before the International Court of Justice are the states. That's why the decisions of the ICJ in the field of private international law are so rare to be found, but it doesn't mean that they are unavailable. They are. Also, we were talking about the international jurisprudence and the role that they played. I mean, the German, the Italian, French, and Dutch schools of law, that they played a vital role in shaping and developing the rules of private international law. And I gave you an example here for Savini and his opinions and how they played a vital role in shaping and developing the private international law rules. Well, also, we were talking about the national sources of private international law, especially in the fields of the nationality, conflict of laws, and conflict of jurisdictions. And I gave you examples for this matter. Regarding the nationality, I told you before that there is a special, uh, let we say, a special legal position regarding the nationality and the Palestinian legal system, simply because there were a lot of accords or a lot of codes regarding the nationality promulgated through the agencies and the authorities since 1925. I mean, since the Ottoman Empire or the Ottoman Mandate till the Palestinian National Authority, which makes the nationality matter of a complex character. And we will discuss this later, inshallah. So today we will start with the first subject matter of private international law, which is the core subject matter of our course for this semester, the nationality. So nationality, we will highlight the nationality according to the Palestinian legal system and also according to the comparative law. So some points, and I mean within these slides, we will talk about the nationality according to the comparative law, I mean in general. Then we will shed the light on the Palestinian nationality laws and their provisions regarding the nationality matter. So we have a question here. In your opinion, why is nationality important? هذا المفترض كان سؤال يعني نعرضه للنقاش قبل ما نبدأ حلقتنا أو محاضرتنا في قاعات الدرس، ولكن هيك الظروف اليوم، فراح أحاول أنتقل إلى شرح الموضوع مباشرة للسؤال اللي احنا طرحناه اللي هو why is the nationality important? Well, actually, the right of nationality is described as the right to have rights. هيك ببساطة قانون أو حق الجنسية بيسموه الحق في اكتساب الحقوق. لأنه ببساطة if you do not have or if you don't enjoy the nationality, it means that you are deprived from enjoying the other rights. مش the right to life، يعني مش من بينها، يعني everyone has the right to life uh, because it's not linked with any nationality. Every human being has the right to life regardless to his nationality. However, The right to nationality makes you capable to enjoy the other rights. For example, the right to stand for elections, the right to vote in the elections, the right to hold public offices, the right to exercise any fundamental right. That's why we describe the right of to have a nationality as the right to have the other rights. So let's read it. It's mentioned that the right of nationality is of a paramount importance to the realization of the other fundamental human rights. So possession of a nationality carries with in the diplomatic protection of the country. Simply, when a person is for example, is humiliated, legally humiliated on the territory of a foreign state, if the person is persecuted on the territory of a foreign state, then his state can defend him through something called the diplomatic protection action. الدعوة للحماية الدبلوماسية. طبعا هذا حق بتمارسه الدولة لحماية رعاياها الموجودين في دولة أجنبية إذا كانوا بيتعرضوا لاضطهاد when they seek the national courts of the foreign state, but this national courts or these national courts do not reply to their demands. So in this case, when the national courts, I mean of the foreign courts, they do not reply to our demands as foreigner people, then we can demand for the protection or the diplomatic protection of our state, and our state can intervene in this case in order to protect us as subjects of that state. يعني دعوة الحماية الدبلوماسية بتمارسها الدولة لحماية أفرادها الأجانب، أفرادها عفوا المواطنين الموجودين في الدولة الأجنبية، بس بشرط أنه يكون الفرد الموجود في الدولة الأجنبية استنفذ كل الطرق على الصعيد الوطني، ومع ذلك المحاكم تبع الوطنية هاي تبعت الدولة الأجنبية تتنصل له، فيمكن عندئذ أن تحرك الدعوة أو دعوة الحماية الدبلوماسية أن تحرك من قبل مين؟ الدولة التي ينتمي إليها أولئك الرعايا الأجانب. فهذا الكلام لا يمكن أن يتحقق إلا إذا كان الفرد اللي أنا بدي أحرك دعوة الدبلوماسية كدولة بتمتع بجنسيتي. عشان هيك بنقول the possession of the nationality carries within the diplomatic protection of the country of the nationality, and is also often a legal or practical requirement for the exercise of the other fundamental rights. So consequently, the right of the nationality has been described as the right to have rights. That's why the nationality deems so important in this case. Okay, so the what you have to know is that the nationality is important simply because it is linked with the matter of the diplomatic protection of the country of the nationality. Number two, it is a practical or legal requirement for practicing the other fundamental rights, like the right to exercise the political uh, freedoms, like for example running for election. I mean, to be uh, one of the uh, one of the persons who stands for the election، واحد من الناس اللي بيترشحوا for a public office, or the right to vote in the election، انك تكون voter. هذا امر بتعلق بانه تكون عندك جنسية الدولة اللي انت بدك تعمل تشارك في الانتخابات فيها. So this is why the nationality is important. So I highlighted here in the red color the most important axes. Well, the diplomatic protection, it is a practical requirement for the fundamental rights. It is described as the right to have rights. Okay, that's why we call it right to have rights, because it's linked with, it is a preliminary requirement in order to practice the other rights. Okay, well, individuals who lack the nationality or an effective citizenship are therefore among the world's most vulnerable to human rights violations. Well, this is a normal result. If you do not enjoy the nationality, this means that you are deprived of a high number of the fundamental rights. Okay, so they are among the world's most vulnerable to human rights violations. هم أكثر الفئات هشاشة في تعرضهم للانتهاكات المتعلقة بحقوق الإنسان. In recognition of the importance of having a nationality, a number of regional and international human rights and instruments include the right to have a nationality. So, what are these? I want to give you examples for the regional and the international uh, uh, documents and instruments which affirms on the right to have a nationality. For example, Article 15 of the Universal Declaration of Human Rights, 1948, it states that everyone has the right to a nationality. So everyone shall enjoy it. So it means that no one shall be without nationality اللي هم الأشخاص اللي احنا بنسميهم عديمي الجنسية or the stateless persons. Stateless persons means people who do not enjoy any kind of nationality for multiple reasons. We will discuss them later. However, these articles mean that no one shall be stateless. So everyone, in other words, shall have a nationality, and that no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. So everyone has a right to have a nationality, and he has freedom to change this nationality when he wants to do this, but he mustn't violate the rule that he mustn't be a stateless. بتغير جنسيتك بس مش معناته انه انت اليوم جنسيتك الفلسطينية تسقطها عنك وتصير stateless. يعني ما ينفعش. If you have two nationalities, you have the right to change from one to another one. You may drop one of them. So in this case, you are not a stateless. So it's okay to change your nationality in this case, okay? So every human being has a right to nationality. Every human being has a right to change his nationality, and he cannot be denied to practice this right. And also every person has a nationality that he shall not be arbitrarily deprived of. فعش ينحرم أي شخص طبعا برضو من جنسيته هاي. طبعا هون في هايبر لينك، لو انت ضغطت عليه حتلاقي the American Convention on Human Rights Article 20. It also affirms on the right to have a nationality, and also it affirms on the right to not to be arbitrarily deprived of this nationality or denied the right to change this nationality. Okay. Now, the right to a nationality is often articulated through protection of the rights of children. Sometimes some instruments regarding the rights of children, it talks about the nationality, it articulates the right to nationality. And the principle of non-discrimination, like in the CEDAW convention, and also the convention on the elimination of all forms of racial discrimination. You may find rules and provisions regarding the nationality and the right to nationality. For example, here the convention on the rights of the child, it states that every child has a right to acquire the nationality. And also Article 5 of the Convention on the elimination of all forms of racial discrimination. It requires the states to prohibit and eliminate racial discrimination in all its forms, and to guarantee the right of everyone without distinction as to race, color, or national or ethnic origin to equality before the law, notably in the enjoyment of the following rights. And it mentions one of these rights, which is the right to the nationality. So, as mentioned here, the right of a nationality is articulated through the protection of rights of children, and here is the example, the Convention on the Rights of Children. And also, it is articulated within the principle of the non-discrimination, and this is an example, which is the CEAF or the convention. Um, Despite actually the recognition of the right to nationality, and despite the fact that the UDHR says that no one shall be stateless, we can say that there are currently at least 10 million people who do not enjoy the nationality, and therefore they are stateless. So, stateless here means people who do not enjoy the nationality. So, stateless here means persons who do not enjoy the nationality. Okay. While statelessness is a global problem, this means انعدام الجنسية. It is a name for the stateless. So it is particularly prevalent in East Asia, Central Asia, Eastern Europe, the Middle East, and several countries in Africa. So these are the regions where we have people who suffers from who suffer from the problem of the statelessness. Countries with the greatest number of stateless persons residing within their borders are Cote d'Ivoire اللي هي ساحل العاج، إستونيا، كويت، لأنه عندنا مشكلة ناس بسموهم مش عارف إذا سمعتوا عنهم، باسمهم البدون. So بدون جنسية، يعني مشار إليهم بكلمة بدون. So it means without nationality. So we have the problem, as I mentioned, Cote d'Ivoire, Estonia, Kuwait, Latvia, Myanmar. These people, or these people who live or reside within the borders of these states uh, are stateless. They do not have or even enjoy the nationality. So what is the nationality? Now we know what is the importance of the nationality. It means the right to have rights. Also, we mentioned that multiple number of regional and international instruments affirms on the right of having a nationality. And despite these facts, we have a high number of people who do not enjoy nationality, which is the case of statelessness. Now, let we move to the definition of the nationality. What do we mean by the nationality? Well, actually, there are several trends in defining the nationality. Uh, for example, the individual or inter alia, the individual's legally affiliation to the people who make up the state. في عندي عدة تعريفات اللي هو جنسية، وهذه التعريفات تختلف عن بعض البعض من حيث الرابطة اللي أو طبيعة الرابطة اللي بيعتبروا إنه الجنسية بتربط الشخص من خلالها بدولته. هل هي رابطة قانونية بينتمي من خلالها الفرد للدولة، ولا رابطة طبيعتها سياسية بينتمي الفرد من خلالها للدولة، ولا هي رابطة mix between the legal and the political character. So, of these examples for the definitions of the nationality, there is a definition which says that the nationality is the individual's legally affiliation، هي التبعية القانونية من الفرد to the people who make up the state، تبعية الفرد للشعب لشعب الدولة، أو تبعية الفرد للشعب المكون للدولة. The second definition in the blue here, it says a political link between the individual and the state. هي عبارة عن رابطة سياسية تربط بين الفرد والدولة according to which، واللي بمقتضاها the individual is considered one of the elements constituting the state، واللي بموجبها بيعتبر الفرد عنصر مكون في الدولة. واللي بقصده طبعا عنصر مكون في عنصر اللي هو the element of the population of the state. And the third definition here, it says that the the link which bonds between the state and the individual is of a legal and political character. So it says that it is a legal and political bond or link which matches between the individual and the state. That's why we can say that the differences between these three definitions of the nationality is regarding the nature of the bond or the link which links between the state and the individual. So some people finds that the relation between them is a legal one. Others find it political one, and the other find it as a legal and political one. Okay. So we notice from these definitions that there is a difference in the definition of the nationality. So one team favored the legal relationship between them. Another team favored the political aspect, and the third group combined the political and the legal considerations for the nationality. However, everyone considers that the nationality is an association or relationship between the individual and the state. Therefore, nationality is based on three essential pillars: the individual, the state, and the relationship between the individual and the state. Okay, regardless to the type of these relations. However, I may support the legal relationship between them. Simply, I describe it as a legal relationship because it's regulated through a law. Since the relation is regulated through a law which decides the cases of acquiring the nationality, dropping the nationality, and how to change the nationality, that's why we can say that the uh, the relationship between the state and the individual through the nationality is a legal relationship. Okay, but it is politically affected. Well, perhaps the aspect that prevailed over all aspects is the legal one. That's what I mentioned before, as is as it is the more correct one because only local law grants, withdraws, and defines the details of the nationality and its effects. And the political aspect is one of these effects. بقول انه صحيح انه في الرابطه وصفت بانها رابطه انتماء سياسي، والبعض قال رابطه قانونيه، والبعض قال بانه هي عباره عن رابطه تجمع بين الاثنين. لكن اللي ساد بين الفقه هو اعتبار انه رابطه الجنسيه هي رابطه قانونيه تجمع بين الفرد والدوله. والسبب في ذلك انه وصفها بوصف القانوني بيرجع الى انه فعلا الجنسيه تنظم بقانون بالدرجه الاولى، والقانون هو اللي بيحدد أسس كسبها ومنحها للأفراد وإسقاطها عنهم، وكل التفاصيل الصغيرة المتعلقة بالجنسية بينظمها قانون. حتى التفاصيل المتعلقة بالجنسية واللي بينظمها القانون قد يكون من بينها العنصر السياسي. يعني إنه الدولة تيجي تقول everyone who is a son of a national mother shall acquire her nationality except فراغ الجنسية الفلانية. يعني يجي يقول لي كل من هو مولود لامرأة مثلا مصرية يتمتع بالجنسية المصرية، ما عدا مثلا ما عدا المرأة المصرية المتزوجة من جنسية فلان، وحدد لي دولة معينة. It may because there is political conflicts between Egypt and that state. So this is a political matter, but it is regulated even by the local law which grants the nationality itself. So we can say that the effects of the nationality are regulated through the law of the nationality. One of these effects is the political aspect itself. Also, an individual may be legally subordinate to the nationality of two or more countries, but he cannot be politically affiliated with more than one country. يعني ليش بنقول انه هي رابطه قانونيه مش سياسيه؟ لانه رابطة قانونية لأنه الفرد عمليا بنتمي لقانون دولة واحدة، لكن ما اقدرش أقول عنها رابطة سياسية لأنه ممكن يكون الفرد متمتع بأكثر من جنسية. أوكي، ممكن يكون عنده أكثر من جنسية، فبقدرش أقول والله هي رابطة سياسية لأنه مستحيل أقول إنه هو منتمي سياسيا للدولتين في آن واحد. صعب إنه الإنسان يكون مرتبط سياسيا بأكثر من شغلة بنفس الوقت. ما ينفعش يكون والله he belongs to Fatah and Hamas at the same time. Okay, so the person here is affiliated politically to one state, but he is not imagined to affiliate politically to two states at the same time. It may happen, but it may happen in a very limited extent. Okay? Although we prefer the legal aspect, we believe that this aspect is politically affected, as we mentioned in our example regarding Egypt. The nationality law is a law of a political nature like the constitutional law. So the nationality is like the constitutional law, it is affected by the politics. Okay? To sum up, nationality is a human right. Every individual has a right to a nationality of a country, and it is not permissible to arbitrarily deprive any person of his nationality, nor the right to change it. Okay, dear students, so all you have to know in this lecture or from this lecture is that the nationality is the right to have rights. It is important for practicing the other fundamental rights. It is required for the matter of the diplomatic protection of the state. The definition of the nationality, we have three definitions, but we prefer one of them, which is the legal nature definition, or the legal link definition. And finally, we have to know that the right of nationality is articulated in multiple number of the or various number of the legal instruments, whether nationally or internationally or regionally even. And we have to know that the matter of the nationality is articulated in the matter of the non-discrimination between people, and actually it is articulated also in the documents which pertain the right of child. Okay, so to this end we reach the end of our lecture for today. Thank you very much, and I see you inshallah in the coming lecture regarding a new topic, which is the how to acquire, generally how to acquire the nationality or the ways of acquiring the nationality. Thank you very much and goodbye.